Well, it's not time now to make a complete report of all the actions that were undertaken till now, of which we no doubt this project represents one of the most fulfilled examples. Certainly, we owe so much to the work of the Committee of Equal Opportunities, to the Comitato Unico di Garanzia, the so-called CUG, that has carried out in our university a lot of work. And this is why today the University of Pisa has become a much better place, I think, for studying, working, and a forefront institution for a fairer world. I'm referring to all the educational activities promoted by our teaching staff, or of the seminars organized for lawyers and professionals, as well as to events open to the public, to the citizens, and promoted by our university as last year's event dedicated to the 10th-year anniversary since the Istanbul Convention signature within the framework of this project. And as another example, let me mention also our commitment to the drawing up of the bilancio di genere, the gender budgeting, and of the gender equality plan that was approved in December 2021, that led to the opening of an anti-violence desk open to all the universities in Pisa. So this is a set of tangible initiatives following others carried out during the last years, such as the establishment of the so-called consigliere di fiducia, the confidential counselor, whom all the university community members can contact for a support against harassment and discrimination, or the approval of a regulation for the activation of the alias career alias, allowing simplified procedures and the extension to the whole university population, not only students, but also teaching and administrative staff. Why have we have done all this? We have done all this because we are aware that the universities play a strategic role in society, becoming crucial for the cultural change required by these issues. An awareness that relies also on the fact that the ineffectiveness and incompleteness of many changing attempts is often due to the lack of cultural tools by the recipients, making all kinds of reforming initiatives bear to results. Academic research, teaching activities, and community raising awareness among our community members about issues as gender have, I think, a vital role in the development of and the success of policies and programs on these topics. University education ensures, in fact, the transfer of knowledges and skills to students and population, thus also contributing to shape the moral character of new generations and making young people responsible citizens with civic sense and critical consciousness. If the university accomplishes its task and fulfills the high expectation as a leading force for social development, then it proves to be up to the role of cornerstones of our societies, and so capable of generating economic prosperity, social life quality, and political stability that many recognize to it. Here in Pisa, we firmly believe in this. That's why I warmly thank you all for accepting our invitation to join this panel discussion. And I'm really grateful again to Professor Stradella and to all the guests for involving me in the occasion of, in this occasion. I care so much, as Elettra knows, and I hope a significant guidance for future will rise from here. So I thank you for the attention and wish you a good job. Thank you very much.
Thank you very much. Yesterday, several brilliant scholars and lawyers discuss in depth the issue of access to justice in a gender perspective, and touching on several aspects of the topic. The Today Roundtable gathers together, online and in presence, a judge of the European Court of Human Rights, a member of GREVIO, a member of the European Parliament sending a message, we will listen to it in a moment, and a member of the Italian Senate. Unfortunately, Emanuela Navarretta, who is a judge at the Italian Constitutional Court, could not be here today. She sent her greetings, and she is very sorry not to be here, and she send her, as I said, as greeting and the best wishes for our work today. Myself, with friends and colleagues involved in the project, and I like to mention them: Elettra Stradella, Valentina Bonini, Angioletta Sperti, Valentina Calderai, Elisabetta Catelani, Giovanna Spanò, wish to thank you all for being here today and having accepted our invitation to be part of this roundtable in Pisa this morning. Yesterday, inspiring presentations highlighted some of the obstacles that hinder access to justice, and those obstacles are legal, judicial, economic, social, and cultural. Yesterday, access to justice has been defined in several ways, but we all agree that it's clear that access to justice is functional and crucial for the protection of human rights in a non-discriminatory way, and to parliaments, international bodies, courts are of course also crucial to ensure access to justice and enforcement of rights. The legislator is called to create the norms, and that a responsibility to ensure that these norms are formulated to actually ensure full non-discriminatory access to justice. The judge is required to apply those norms, and some of those provisions have been formulated in a historical moment which is very different from the present one. So the judge, he, she, is called to apply this provision, taking into account the new sensitivities. And at the same time, those sensitivities are not always understood or shared by all the society. So before giving the floor to our participants to the roundtable, we will listen to a message sent by Pina Picierno, who is a member of the European Parliament. She is one of the vice presidents of the European Parliament, and she is also a member of the Committee on Women's Rights and Gender Equality of the European Parliament. She was rapporteur on several reports of the European Parliament, and for instance, on measures to prevent and combat mobbing and sexual harassment. She was also shadow rapporteur for the report on the impact of intimate partner violence and custody rights on women and children, and a report with a recommendation to the Commission on identifying gender-based violence as a new area of crime. Before listening to her message, I would like to underline that the date of this conference was identified by the organizers long before September 25 became an election day. And we regret these concomitants, which also prevented some person from being present. So I will questo, vero? Era quello sì. Ok.
Dear professors, dear guests, dear all, it's a pleasure to contribute to this high-level panel about gender equality and justice. In fact, this topic is very, very dear to me since I have worked for many years in the Committee on Gender Equality at the European Parliament. As you know, gender equality is one of the fundamental values of the European Union. For this reason, the European Parliament is strongly committed against all forms of discrimination, and it always works in order to accomplish gender equality in all sectors. During the negotiations for the next generation EU, we made sure that this aspect would be taken into account. If you go and read the regulation establishing the Recovery and the Resilience Facility, you will find a whole recital about the impact of the pandemic on women. We were among the first to warn against the so-called shadow pandemic, namely the aggravation of all the pre-existing gender gaps. Therefore, we called for investment that guarantee women empowerment, underlying how this will also have a positive effect on gross domestic product. And we fought very hard to include gender equality in the requisites for the national recovery plans, so that if a state did not include specific and concrete measures promoting gender equality, this could be judged negatively by the Commission. More in particular, the European Parliament gives great attention to gender equality and justice in its every act. For example, we have recently asked for the modification of the Article 83 of the Treaty on the Functioning of the EU. As you know, this article concerns the EU competence in criminal law, and we are working to add gender-based violence to the so-called Euro crimes, so that we may have a common frame of reference in the whole European Union. We have also taken a clear position on specific issues, such as the impact of intimate partner violence and custody rights, to guarantee access to justice for both women and children, and to fight against the use of the so-called parental alienation syndrome. Finally, we are also working on the new directive against gender-based violence that would work on many different levels: prevention, protection, prosecution, coordinated policies. There are, of course, many other texts I could speak of, but my point is that the European Parliament is doing whatever it can to promote gender equality and access to justice for women. And we are working it to make it a reality not in 10 years, but now. As we say, justice delayed is justice denied. Women cannot wait anymore. The rest is up to us. We have to commit to gender equality at every possible level and as a society, because gender equality is key for our future in Italy, in Europe, and in the whole world. Thank you very much for your attention.
Now we give the floor to Senator Valeria Valente. She's a member of the Italian Senate and president of the Parliamentary Commission of Inquiry into Femicide, and as well as other forms of gender-based violence. The commission was established by Senate in October 2018 and then extended. The Commission approved several important documents, a report on secondary victimization of women who suffer violence and their children, a report on the treatment pathways for men perpetrators of violence in emotional and gender relationship, an important report on the judicial response to femicide in Italy. So I give the floor to Senator Valente. Thank you very much for being here with us this morning. You have the floor.
Grazie, buongiorno, chiedo scusa anche di avervi chiesto di slittare tempi e modalità dell'intervento, ma purtroppo, come è stato detto, campagna elettorale, domani si vota, io sono candidata proprio nella mia città e quindi diventava complicato sia essere in presenza che rispettare i vostri tempi, però grazie davvero per l'invito, soprattutto grazie davvero per aver messo in piedi questa 2 giorni e questa riflessione che è tanto interessante, preziosa anche per il nostro sistema di contrasto alla violenza maschile contro le donne. Abbiamo bisogno dell'apporto accademico e proverò anche a dirvi in poche parole, in pochi minuti, perché il vostro apporto è veramente prezioso, il vostro punto di vista. Allora, partiamo dal titolo che avete scelto di dare a questa sessione di lavoro, l'accesso alla giustizia, ma soprattutto l'applicazione, in che modo funziona il sistema normativo previsto in Italia per il contrasto alla violenza maschile contro le donne. Intanto il dovere di dirvi che le norme vigenti in questo momento nel nostro Paese, l'intero impianto normativo in questo momento disponibile in Italia è sicuramente un impianto solido e robusto che affronta il tema della violenza maschile contro le donne in maniera seria e strutturata. Manca forse ancora di un coordinamento tra tutte le norme che sono state prodotte in questi ultimi anni, tanto è che in una delle nostre ultime, se non addirittura ultima relazione delle 12 che abbiamo costruito in questi anni, che abbiamo fatto in questi anni, indichiamo come una ulteriore urgenza quella di una legge organica, modello spagnolo, un testo unico se lo vogliamo chiamare, sull'intero sistema normativo, perché abbiamo prodotto tante norme molto spesso in una logica di emergenza e si sono sovrapposte e si sono, come dire così, stratificate l'una sull'altra nel tempo. Qualche contraddizione resta ancora, ma soprattutto resta la difficoltà di avere una visione d'insieme anche per gli operatori che poi sono chiamati ad applicare le norme. Quindi intanto questo. Vi dicevo di un impianto sicuramente solido, robusto e efficace. In termini, il dramma che lo è sicuramente in termini astratti, teorici. Purtroppo però se vediamo l'applicazione concreta di queste norme, in modo particolare nel sistema della giustizia, proprio quello a cui voi fate riferimento, quello preso in esame dalla vostra 2 giorni, lì iniziano a venire fuori diverse criticità che noi come Commissione parlamentare d'inchiesta abbiamo avuto il dovere, ovviamente proprio per nostro compito istituzionale e politico, abbiamo avuto il dovere di sottolineare. Lo abbiamo fatto con nettezza, spero anche chiarezza, con parole credo sinceramente di verità, anche supportate dai migliori operatori che a vario titolo operano proprio nelle aule di giustizia, a partire da avvocati, magistrati e consulenti, tra i migliori in Italia e quelli che si sono dedicati a questo fenomeno, al contrasto del fenomeno della violenza maschile contro le donne. Noi abbiamo fatto tante relazioni, voi avete fatto riferimento a una in modo particolare, che è quella della vittimizzazione secondaria. Io ho il dovere di dirvi che questa si inquadra dentro un'altra serie di relazioni, in modo particolare altre 2, legate al sistema della giustizia, all'analisi del sistema della giustizia. Noi abbiamo fatto una prima relazione che fotografa il livello di formazione del sistema giudiziario, come il sistema giudiziario oggi è formato per contrastare in maniera adeguata il fenomeno della violenza maschile. Abbiamo dovuto rilevare che purtroppo la formazione non solo è complessivamente ancora non adeguata, ma è soprattutto una formazione distribuita nel territorio a macchia di leopardo e comunque in maniera non omogenea e non uniforme tra i diversi uffici giudiziari. In modo particolare in questa prima relazione, giusto solo un accenno, abbiamo rilevato che le procure sono sicuramente più specializzate e più formate dei tribunali civili, ma ancora di più lo sono le procure grandi, anche le procure piccole hanno qualche difficoltà, sicuramente hanno tante difficoltà sul terreno della formazione, che sono invece, capirete per tante ragioni, molto preziosi i giudici per le indagini preliminari. I GIP hanno sicuramente ancora un lungo percorso da fare in termini di formazione, e per noi quelli invece sono preziosi soprattutto per la concessione delle misure cautelari indispensabili per proteggere in maniera adeguata le donne dai primi, diciamo, come dire, segnali di violenza. Quindi sicuramente questa fotografia. A questa abbiamo fatto una successiva indagine che indagava forse un settore più semplice di quello della vittimizzazione secondaria, relativo alla vittimizzazione secondaria, che è appunto il campo un po' del penale, provando a capire soprattutto in materia penale perché una donna denuncia e poi finisce ancora per non essere protetta in maniera adeguata. Intanto abbiamo rilevato che denunciano ancora troppo poche, l'analisi è del 2017 e 2018, ma perché ovviamente abbiamo dovuto considerare anche il tempo necessario a che la vicenda giudiziaria fosse conclusa. E però sicuramente quindi qualche numero è, come dire, è più confortante, diciamo, secondo me in questi anni è cresciuto sicuramente il livello delle denunce, ma se guardiamo a riferimento 2017-2018 vediamo che soltanto il 15% delle donne denuncia, e soprattutto, cosa ancora più grave, soltanto il 64% delle donne ne parla con un'amica, con un familiare. Quindi il tema è, prima ancora che l'accesso alla giustizia, è perché le donne non vi fanno ricorso. Perché, come dire, hanno proprio una fatica iniziale intanto a riconoscere quello che stanno subendo e poi a parlarne, prima ancora che al sistema giudiziario penale nella sua interezza, addirittura ad un'amica e quindi ad un eventuale avvocato, o comunque a ricorrere, no, alla giustizia. Qui abbiamo analizzato molte cause, sicuramente il contesto nel quale matura questa consapevolezza è la vera criticità per noi, cioè il contesto sociale, culturale nel quale una donna deve avere la possibilità di non sentirsi giudicata, etichettata, colpevolizzata, e invece ancora oggi è così. Nella stragrande maggioranza dei casi, del resto, un'indagine fatta dall'Istat ci dice che oltre la metà degli italiani e delle italiane nel 2019 pensa che una donna che subisce violenza se l'è cercata o non ha fatto tutto quanto in suo potere per evitarlo. Questo ci fotografa chiaramente il quadro italiano su questo fenomeno. Quindi una donna che si rivolge alla giustizia sa di dover passare per un giudizio prima ancora che dell'ufficiale giudiziario al quale dovrà rendere la denuncia, prima ancora di un'amica, di un avvocato, qualcuno che le chiederà sicuramente cosa hai fatto tu, come ti sei comportata. Forse non siamo più alla domanda del come eri vestita, ma siamo alla domanda: hai fatto qualcosa per generare quel comportamento? Cioè, nella serie, che tipo di relazione tu avevi? Ti scrivevi con qualche altro? Sei uscita con qualche altra persona? C'erano ragioni di gelosia fondate? C'è sempre l'analisi del comportamento di lei, sempre l'analisi delle sue relazioni, sempre l'analisi del suo vissuto, e lei a passare sotto la lente di ingrandimento, cioè è la sua vita che viene passata a setaccio. Questo è sicuramente un problema, perché si sente il giudizio, essere etichettate prima ancora che poi, insomma, aiutate, no? Poi semmai la mano arriva, ma arriva dopo, e questo primo invece scoglio che viene difficile superare. Questo dicevo rispetto alla vicenda giudiziaria in materia soprattutto penale. Il tema della vittimizzazione secondaria invece che ovviamente è legato anche alla vicenda penale, perché anche questa è una forma di vittimizzazione secondaria, cioè la donna dopo aver subito una violenza subisce questa forma di vittimizzazione secondaria che è la colpevolizzazione nelle aule di giustizia. Quindi in generale uno Stato che dovrebbe tendere una mano tende invece a colpevolizzare, quindi un'ulteriore forma di violenza. Per questo noi la chiamiamo violenza, diciamo, secondaria, violenza istituzionale, violenza, come dire, una violenza sulla violenza. Se questo è vero in generale per l'intero impianto, diciamo, giudiziario, lo è ancora di più per la materia civilistica, dove, per questo ci tenevo a fare la premessa, sicuramente i giudici, i magistrati, ma tutto, diciamo, l'apparato è ancora meno formato e specializzato diciamo, del campo penale, del settore penale. Quindi noi qui ci troviamo non solo il classico stereotipo e pregiudizio di cui tutti gli operatori sono portatori o portatrici, operatori e operatrici sono portatori o portatrici perché sono cresciute in questo contesto culturale, in questo dato momento storico, in questo contesto sociale. Ma il tema drammatico, e qui manca anche la specializzazione, tanto è che noi cosa abbiamo rilevato con questa indagine di cui mi veniva chiesto conto? Abbiamo rilevato che sostanzialmente l'80% l'80% delle allegazioni di violenza fatte in materia civile, in sede civile, non viene indagato ulteriormente nel corso del giudizio da parte dell'autorità giudiziaria. Cosa vuol dire? Che se una donna decide di separarsi dal proprio compagno e però, diciamo, nella sede civile di separazione, lì dove il giudice deve sostanzialmente è chiamato a valutare i rapporti patrimoniali tra i due, ma anche i principi di affidamento rispetto ai loro minori, ai loro figli, se quella donna allega attestazioni di violenza subita, quelle allegazioni, quelle attestazioni non saranno prese in considerazione dal giudice che non le ritiene rilevanti ai fini della decisione in materia civilistica. Per noi ovviamente la cosa perché diventa molto grave e seria? Perché diciamo lo diventa sia dal punto di vista delle decisioni patrimoniali, ma lo diventa soprattutto rispetto alla vicenda relativa alla attribuzione della responsabilità genitoriale. Perché? Perché la Convenzione di Istanbul, che ricordiamo sempre legge già di questo Stato, essendo stata ratificata dallo Stato italiano, prescrive all'articolo 31 che i figli minori devono essere messi sempre in una condizione di sicurezza, sia a dire la verità sia i minori che la donna, devono essere messi, e quindi di fronte a un padre violento non c'è soltanto il tema pure importante, no? Della violenza assistita, quindi il tema è sicuramente quel minore avrà, no, un danno, lo dicono tutti gli studi, che un bambino che assiste a violenza tendenzialmente rischia di diventare o un uomo violento o un uomo che subirà violenza nel corso della propria vita, cioè rischia di avere ripercussioni importanti, tanto è che noi siamo passati come legislatore italiano dal definire questa violenza assistita a violenza diretta nel codice rosso, legge 69 del 2019. Ma al di là di questo, il tema che oggi io volevo mettere anche rispetto alla vostra richiesta in luce è che la valutazione rispetto alla responsabilità genitoriale, non considerando gli episodi di violenza, non prende in considerazione le necessità di dover mettere in sicurezza quel minore da episodi di violenza, perché non legge la violenza. Cioè nella sede civile il tema è che la violenza non viene letta, viene derubricata a un fatto non rilevante ai fini della decisione in sede civilistica, ragion per cui è altamente probabile che un bambino possa essere affidato per mano del giudice, quindi per mano dello Stato, anche al padre violento. Soprattutto questo accade quando quel padre, insieme ovviamente a avvocati che ormai sono specializzati su questa materia e su questo fronte, provano a tirare in ballo il fenomeno dell'alienazione parentale, ovvero il condizionamento che quella donna pone in essere nei confronti del figlio, condizionando sostanzialmente in maniera negativa il rapporto tra il figlio e il padre. Qui ho il dovere di dire che non solo questa teoria è stata disconosciuta, cioè non riconosciuta da tutta la comunità scientifica internazionale, nonostante questo noi abbiamo rilevato nella nostra indagine, viene puntualmente richiamata in moltissime decisioni dei giudici, in moltissime decisioni. Quindi se da un lato non viene rilevata la violenza, dall'altro lato invece viene rilevata questa alienazione parentale. Ricordiamo, violenza deve essere riconosciuta soprattutto rispetto alla vicenda affido dei minori perché è prescritto dalla Convenzione di Istanbul, ma questo non accade nelle aule di giustizia civile, mentre accade che viene richiamata l'alienazione parentale, che è un fenomeno invece disconosciuto dalla comunità scientifica, che quindi non ha rilievo scientifico. E seppure oggi non viene più chiamata così, viene chiamata in molti altri modi, ma il senso è sempre lo stesso, cioè viene quella madre, viene, come dicevamo prima, passata a sedaccio il suo comportamento, quindi non solo in termini di provocazione, cioè di quanta è la sua responsabilità per avere generato il comportamento violento di quell'uomo, ma viene ritenuta responsabile dell'allontanamento del figlio, del minore nei confronti del papà, dell'uomo. Questo in ragione di un principio che è sotteso, diciamo, alla nostra cultura giuridica e civile, direi, e sociale, che un bambino ha sempre e comunque diritto di avere un padre e una madre, indipendentemente dalla rilevazione o dal fatto che si possa constatare anche che uno dei due genitori è una persona violenta. Questo quindi contraddice non solo quanto detto alla Convenzione di Istanbul, ma anche la Convenzione di diritti internazionali nei confronti della tutela dei fanciulli e dei minori. È un tema sicuramente insidioso, difficile da affrontare, ma noi abbiamo detto, lo abbiamo ripetuto e siamo contente anche che su questo terreno si siano pronunciati a voce autorevoli, a partire dal già presidente Giuliano Amato della Corte Costituzionale, che quando abbiamo presentato l'indagine ha detto chiaramente: attenzione, in questi casi il pregiudizio sostanzialmente viene sostituito all'attività di accertamento del giudice, perché qui c'è un pregiudizio nei confronti di una donna che viene ritenuta responsabile di questo allontanamento, come se quella donna avesse lavorato per condizionare il comportamento del bambino nei confronti del papà. Sostanzialmente la donna viene ritenuta responsabile di un allontanamento che è contrario al principio sacrosanto, secondo diciamo il sentimento, direi, comune, che è quello che un bambino deve sempre comunque avere a tutti i costi quel che costi, un padre e una madre. Queste sono, diciamo, sostanzialmente i rilievi che noi abbiamo mosso al nostro ordinamento, dicendo che dando anche dei suggerimenti alla fine della nostra relazione. Che cosa diciamo? Che il tema ovviamente si può vincere innanzitutto abbattendo stereotipi e pregiudizi, innanzitutto chiedendo a tutte le figure coinvolte di essere specializzate, formate, e in modo particolare abbiamo acceso un focus sui consulenti che vengono chiamati in ballo nei procedimenti giudiziari civili, in modo particolare gli psicologi per quelli civili e per quelli minorili gli assistenti sociali. E molto spesso sulle loro relazioni che si fonda la decisione finale del giudice, sulla quanto questa donna sia alienante, quanto questa donna sia condizionante, quanto questa donna sia malevola, quanto questa donna neghi il diritto d'accesso del padre, quanto questa donna sia condizionante nei confronti del minore. Perché molto spesso gli psicologi, invece di fare, diciamo, un'attività che è sostanzialmente un'attività valutativa, si sostituiscono e fanno un'attività di accertamento, che invece è quella che spetterebbe al giudice, quindi invertendo i ruoli, e anzi il giudice poi non fa altro che prendere atto della relazione dello psicologo, dell'assistente sociale, e sostanzialmente nella pronuncia definitiva, nella sentenza, nell'ordinanza, insomma nel pronunciamento definitivo, non fa altro che riprendere la valutazione, che ripeto, quindi in questo caso si sostituisce all'accertamento, posta in essere dal consulente d'ufficio, quindi dal consulente esso sia psicologo o assistente sociale. In questo caso quindi è veramente indispensabile utilizzare consulenti, professionalità adeguate, specializzate, che conoscano il fenomeno della violenza e soprattutto che non si rifacciano a tesi dichiarate apertamente a scientifiche, prive di rilievo scientifico. Queste sono un po' le cose che abbiamo messo in luce. Ovviamente quindi il tema è specializzazione degli operatori, formazione adeguata e soprattutto abbattimento di stereotipi e pregiudizi, ma anche, mi permetto di dire una cosa più generale che attiene agli stereotipi e pregiudizi, che forse è quella di iniziare a credere e dare voce alle donne, oltre che ad applicare leggi di questo Stato, a partire ovviamente dalla Convenzione di Istanbul. Questa è stata la nostra indagine. Tenete conto che per rigore scientifico non vi ho detto che questa indagine è stata svolta su oltre 1600 fascicoli, tra civili, minorili. Abbiamo, credo, analizzato centinaia di migliaia di pagine. Lo abbiamo fatto rispetto sia a casi che ci sono stati segnalati, ma poi anche con un campione costruito in maniera statistica con l'Istat, per dire quanta era la rilevanza di questo fenomeno. E il dramma è che se non è rilevante in termini di numeri enormi, lo è nella dimensione del fenomeno, perché se diciamo che tutte le volte che una donna allega violenza, nell'80% dei casi il giudice non prende in considerazione la violenza, vi renderete conto che siamo di fronte veramente a un fenomeno pericoloso, strisciante e, come dire, che rischia di non essere aggredito se non viene denunciato in maniera, con parole forti. E per questo abbiamo provato a fare il nostro lavoro dicendo delle parole nette e chiare, e mi auguro che ovviamente anche a partire da questi 2 giorni, dalle vostre considerazioni, dalla vostra competenza, dalla vostra attenzione, si possa fare ulteriore luce su questo fenomeno, che è un fenomeno agghiacciante, perché se è vero che la violenza è tutta da condannare, credo che il fatto che a una donna venga sottratta la sua responsabilità genitoriale solo per aver chiesto aiuto allo Stato per mano dello Stato sia qualcosa di ancora più agghiacciante, forse di tante altre forme di violenza che purtroppo ancora oggi le donne sono costrette a subire per mano degli uomini. Grazie a voi.
Thank you very much, Senator Valente, for your comprehensive presentation that gave us an overview of all the issues, not only the legal issues, but also the relevance of the cultural obstacles, and also to suggest how to improve this situation. It's clear that access to justice relates not only to being able to get into court or tribunal, but to receiving procedural, but also substantive fairness in court, but also before being court. Equality and fairness, of course, are undermined by stereotypes that pervade, we cannot negate this, the entire justice system, whether the case in question is in a criminal court or, as you mentioned, in civil tribunals. You also mentioned, and also Pina Picierno refer in her speech to the parental alienation syndrome, and I want to underline the relevance of the issue in line with other international bodies. As you mentioned, the parental alienation syndrome has been rejected. The theoretical basis has been considered groundless, and also the European Parliament approved a resolution containing an important paragraph. Of course, it's a resolution of the European Parliament, so it's what we call soft law, but I think it's rather important that this resolution called on member states not to recognize parental alienation syndrome in their judicial practice and law, and to discourage or to prohibit the use of this theory in court proceeding during investigation to determine the existence of violence. So thank you again very much for being here with us this morning.
Grazie a voi.
Now I will ask the other participant of the roundtable, Dr. Sabato, Lanzoni, to come here to the table. Since I am an international law scholar, before giving the floor to Simona Lanzoni from GREVIO and then to Judge Raffaele Sabato, I would like to underline the relevance of international bodies for the protection and furtherance of human rights and, of course, of the right to have a non-discriminatory access to justice. I think it's clear that it's really fundamental that as many states as possible ratify international treaties, but this unfortunately is not enough, as what is hard for state is to accept the mechanisms, tools of monitoring or of enforcement, in particular when these enforcement tools provide for the possibility for private persons to bring their case and complain before a court or before an international body which is created, established by some of human rights treaties. So if you agree, I start with, I give the floor to Simona Lanzoni. She's a member of GREVIO, which is a group of experts on action against violence against women, domestic violence, provided for, established by the famous Istanbul Convention. Simona Lanzoni is a member of GREVIO, and I give you the floor. Thank you very much.
And so, first of all, thank you very much and for this invitation, and thank you very much to Professor Stradella, Bonini, all of you that have worked for 3 years in this Jean Monnet program. And it's not the first time that I'm participating in a Jean Monnet program. This means that it's very effective because really create a moment of exchange and knowledge, because yesterday I was present and wow, sometimes we really need moment of refreshing and articulating issues so important. So thank you very much for this invitation and for the work that you have done. I really hope that you can follow up this, you can say, this path and these studies and research. So I will do a general frame that, of course, all of you know, but just to permit me to go in little by little. And of course, access to justice is a broad concept and is not a concept of yesterday. It's a universal human right, actually, and there are different bodies that spoke about access to justice. But of course, as belonging to GREVIO, I have a particular attention on women access to justice. And there are so many reports from so many different bodies, from UN, World Bank, Council of Europe, that always underline that women face particular and peculiar obstacle in accessing justice. So this is why there are specific tools to promote this access. It's not an easy task, and it's true, we would like that is now the solution, but in fact it's a process within the time. And so we are part of this process. Perhaps my daughter will see another part of this process and her daughter and so on, you know, so it's just not because I'm negative on this, it's just because I'm positive, because this process start from very few years compared to the century of subordination of women. And so we have a long way to do, and we are here because we are part of this way. So, of course, Council of Europe is doing a lot. And access to justice is, and for women's and women's equality is part of the 5 priorities theme of the Council of Europe Gender Equality Strategy that is going to end next year. And the right of equal access to justice is established by 4 major treaties of Council of Europe. So the European Convention of Human Rights that belong to the court, the European Social Charter, the Convention on Trafficking on Human Beings, and of course, the well-known Istanbul Convention that, as the real name is Convention on Preventing and Combating Violence Against Women and Domestic Violence against women, just because we were needing a specific tools for women. That is the half of the population of the world. So it's not a little piece. So this barrier, as was remembered before, are divided into 2 groups and are institutional barriers. So yesterday we heard about institutional violence. Also, Senator Valente was speaking about, just at the end, institutional violence. And it's a big issue of course, a big issues to overcome. Perhaps this will take some times to overcome. But of course, Istanbul Convention is there to facilitate the commitment of state to overcome the institutional barrier. States can sign and ratify the Istanbul Convention to harmonize the principle and the provision contained in the convention within their legislative system, penal code, civil code, all kind of measure that needs to realize the four pillars, because based on the Article 5 of the Istanbul Convention, the due diligence, state do not have an obligation of results, but have an obligation of means. Mean should put every kind of means, measure, law, whatever is needed to try to prevent and protect from violence, try to compensate victims, try to punish perpetrators. So, Istanbul Convention, we say that is a golden standard. It's a golden standard because it includes results of case law of the European Court of Human Rights in case of violence against women before the 2011, of course, and the principle and value of the European Convention on Human Rights. So sets binding obligation for states to foster women access to justice, including, for example, to promote changes in social and cultural patterns, providing adequate training of professionals working with victims, providing adequate legal information to the victims. And if a state is negligent, yes, this is the problem. So there are institutional barriers. The European Court is there, and after we will hear what's going on. But the convention in somehow is providing a monitoring mechanism which is composed by two bodies, because everybody knows very well GREVIO, but it's not alone GREVIO. The other body is the political body, that is the Committee of State Parties, and GREVIO is the technical one. We are in charge and entitled to carry monitoring evaluation that should help state to identify their weakness from outsider, from which come recommendations that the Committee of State Parties provide to them in order to change their shortcoming. So this is a mechanism that takes time. For example, just to monitor more than 20 countries, we take more than 5 years, just to give you an example. And actually, 37 countries ratified the Istanbul Convention. At the end of my mandate, more or less, we will monitor all of them. Okay, so changes are slow, but continuously. Okay. And after we have the social, cultural, and economic barriers that are rooted in gender norms that hinder women's ability to access justice. And you just think to the traditional role, gender role. So everything that is in somehow define the subordination of women to men in a society. Economic inequalities that make barrier to access to justice. Everything is, is part of a construction that is just the result of century of history. And these situational circumstances, together with personal characteristics such as age, if we have children or not, our legal status, migrant, asylum seeking, refugees, undocumented women, gender identity, sexual orientation. There are so many factors that combine can further limit women's rights and access to justice. So, of course, Istanbul Convention is there with its provision to just give gender responsive legal framework, women's legal awareness and literacy, access to free and quality legal advice and legal representation. They give provision to help countries and civil society to work in this direction. So, sorry, I have to. So, Istanbul Convention include, as you know, different provisions aimed at facilitating the access to justice. And I want to give you some example that we monitor and we evaluate that are weak in all of countries that we met. One of the things that I want to underline is just not Italy, because always, you know, Italians say, yes, we are very bad. We are like the other. We all are bad or good. There are some good practices. Every country has some good practices and some bad practices. So this is why I'm just speaking in general. And for example, we monitor many instances that identify gaps in Article 4, that is on discrimination, particularly in paragraph 3, where there are the absence of effective measure addressing the needs of women belonging, for example, from national minorities, like Roma, like Sinti and Caminanti, like Sami. Sami, it's a population in Sweden. They are in a very rural and remote area, and really, they have a lot of difficulty to access justice. For example, in Serbia, Roma, police doesn't care about early forced marriage because they think it just belongs to a cultural tradition. So just to give you some example, migrant, refugees and asylum-seeking women. We can speak about Italy, about Malta, all the difficulties of women, for example, asylum-seeking, that are not taken into account by the violence based on their gender to request asylum, or the difficulty to access just to a shelter or to an hospital because they need some care. Just because they are a refugee, they don't speak the language, they don't have mediation, and so on. Without resident permit, women without resident permit in Denmark, they do not access at all shelter for women or social services. I can say also Poland, and so on. For example, now Poland, if in case you are abused and you are pregnant, you cannot get an abortion, even if you comes from Ukraine, where there is a war, and you should go to Germany to get an abortion. Women with disabilities, so very difficult to even access the office of the police. And to get information, if you are blind, if you are deaf. So it's not a joke, huh? Women with substance abuse. For example, in Italy, there is protocols. Shelter for Women have specific protocols that forbid to to host women under substantial abuse because they can be a risk for the other women. So where they have to go? And so on. You know, there are difficult work for difficult access to justice for women, lesbian, bisexual, trans women, and intersex. There are no space and no even it's not question of protocol, even, you know, PAP, people expert enough to take them and their experience and to help them how to get out from the violence they live, like prostituted women. Can you imagine if they go to police and they say, during my work, I was abused, and or just in an investigation or in legal procedure, they could not be believed just because they are prostituted women. Women in marginalized area, old women. So, I mean, it's so huge, the fragmentation of vulnerability of women in access to justice. For example, if we are going to see and evaluate the Article 5, as I told you, the due diligence, in general, we as GREVIO, we look at this and we report in Chapter 5 related to Article 29, civil lawsuit and remedies, because of often GREVIO evaluated that there is a lack of adequate implementation of the available civil remedies against state authorities violation in their due diligence obligation. So as you see, I mean, for example, I put Albania, Andorra, Finland, the Netherlands, Spain, just to give you an idea that it's really everywhere, the problem. Montenegro, for example, in particular, has a lenient approach taken toward law enforcement officials who are perpetrators of violence against women and who are often subject to disciplinary action and fines rather than criminal charge in order to not fire them. Or in Sweden, the situation of migrant women was highlighted in our monitoring report when reviewing financial and language barriers that prevent women from suing state actors for liability, particularly migrant women. So GREVIO also emphasized its evaluation, the inadequate collection of data. This is very, very important. This is the bottom. If we do not have data, how we can do good policy? How we can make that the institutional violence stop? And the collection of data on the use of available remedies and their results in order to monitor progress in this area, identify obstacles faced by victims and address them. For example, Belgium, Denmark, Serbia could not provide statistical data on the number of claims lodged by women, victims, and the number of appeals in France. So Italy now have, from very few months, gender statistic obligation now to collect data based on gender. This is a great news. Let's see if it will work, because it will help Italy to make better data collection. Another angle which we can see the due diligence is also the Chapter 6, Article 50, immediate response, prevention and protection. So this article required law enforcement agencies to react promptly and appropriately in the event of violence against women, offering with women immediate protection and working to prevent violence. For example, by using preventing operational measures, and Codice Rosso, for example, in Italy, it's part of this, but is not always and well used, we can say. So the GREVIO report focuses on the application of Article 50 at case stage of the criminal justice process, reporting and investigation, prosecution, and sentencing. Positive action have been taken, for example, in Portugal. I don't want to tell you that everything is bad. There are a lot of good things that is going on during these 8 years. For example, for domestic violence and sexual violence in Portugal, they prioritize these cases for investigation, and criminal court must rule on urgent coercive measure within 48 hours. And it happened in the majority of the state of Portugal. And however, reporting immediate response and investigation by law enforcement are not always good practice everywhere, and often focus more on domestic violence, not on other forms of violence. For example, forced marriage are not taken very much into account. Female genital mutilation also, sexual harassment, sexual violence, and so on. Often there is a long delay in opening investigation. In all countries we saw this. Also because there is a lack of gender understanding of violence against women in the context of investigation. And this results in women not trusting and not reporting. The problem of low prosecution and conviction rates for all forms of violence against women is a fact. GREVIO explored the fact that contribute to low prosecution and conviction rates of violence. It's in somehow one of the main reasons we can find one of the main reasons in the fact that there are not enough professional training also in the justice system. And I include also lawyer, because sometimes, because lawyers are not belong to the state, they are not trained enough, and really sometimes they create a lot of problem to victim of violence. In any case, the problem of not understanding of violence against women create a re-victimization of women, eroding women's trust in the criminal, civil, and also juvenile justice system. And finally, the indirect message to offender is that they will not be held accountable for their action. So the history will be perpetrated. So, of course, Council of Istanbul Convention is somehow all related to access to justice. We have so many articles that speak about this. We have, for example, specialized support services in Article 25, the right to timely compensation in Article 30. So really, I will not read all of them because I think all of you know Istanbul Convention. But finally, the effectiveness of an anti-violence system at national level as well as at territorial, local level depends very much on integrated policies. That is one of the 4 pillars of the Istanbul Convention. Coordinated and financially supported by a state in order to enable and integrated access to justice that is meaningful for a woman who has experienced violence. Coming out of violence is a complex experience. It takes time and does not only have a monofocal dimension, but has a prismatic and transversal dimension that include all elements of a social, economic, investigative, judicial, health, school, housing, work system that participate in a transformation of a society to overcome violence and achieve a new culture of respect and equality between human beings. So thank you very much, and I hope that Istanbul Convention will be part of your studies, because Istanbul Convention need the support of academic people, civil society, judge, and everyone. Thank you.
Thank you very much, Simona, for this very interesting and also moving, I would say, view from inside. And you are doing an amazing job, really. Thank you. I have a question, if I may. The system, if I'm correct, is that the contracting parties of the Istanbul Convention have to submit a report based on a questionnaire that you prepare. What is the, and then you examine, what is the most difficult part of this of this job, of this mechanism, of this monitoring system? Is the creation of
questionnaire is always the same. We have done a questionnaire and we elaborate a questionnaire in 2015. This was the first questionnaire. And this is the same questionnaire that goes to every country for the first time. When we were debating which kind of question to put inside, do we have to just question on justice system or on prevention system, we decide to make question on all, we decide to make question in each chapter because we want to have an overview on what's going on in every country. And now we understand little by little, we publish a peer review after a few years, and we understand that there are countries that are stronger in some section than another. But there is some general issue that are everywhere. Now we are working on the second questionnaire because when we will leave, there are a group of GREVIO members that are at the second mandate, that is the last. And we will leave as heredity, inheritance, a questionnaire for the next coming GREVIO. And we are studying how to structure and where to focus our attention. And of course, now it's interesting, but also another very interesting issue is just that exists a new mechanism, a follow-up of the countries that is done by the Committee of Party just to monitor what they have done of the recommendation that they received the first time. And the questionnaire in the coming here, the new questionnaire will also follow this. So what's the more difficult things is just to take the real information. It's just to receive. Yes, of course. All of us is rapporteur of some countries. All of us read all reports, but we can be focuses on in some countries. And when we go in the countries, we have visit with the authorities. So with the representative of the ministries that are involved in the monitoring. And we visit also other important part of the society, like ombudsperson, women working in shelter and on violence against women, academician, so people that are involved in this work. And it's very interesting because we have two perspectives. We have the institutional perspective and the informal perspective. And often the truth is in the middle. The truth is in the middle, and it's very interesting because you can understand also the difficulties of the institution, that the difficulties that they face. For example, I give you just an example, okay? Before COVID, we were speaking a lot about austerity. Sometime even authorities in different countries, they were saying we face difficulties in law enforcement, in the justice system. Not only training, but to have enough staff to work on it, you know, to be specialized on violence. So sometimes was not the willing, sometimes was really the capacity, the economical capacity. So it's always to understand where is a country, where is a civil society. If there is no civil society that push on this, or if there is a strong civil society, or if there is an institutionalized civil society. There are so many prismatic aspects. For this reason, I say that is really interesting to see how every country is struggling to apply Istanbul Convention, how much is different. And in any case, we see that the wish is to go in this direction. Istanbul Convention and the Convention on Trafficking Against Human Beings are the two conventions of Council of Europe that were ratified and entry into force the faster, faster compared to the other. This means that countries know that there is an issue, that there is a problem, even if at the other. So we had a very strong backlash movement against Istanbul Convention, the withdrawal of Turkey, but now still, you know, we see that the withdrawal of Turkey create so huge momentum of, oh, pay attention. And little by little, new country now comes and ratify. The last is UK, just 1 month, 1 or 2 months ago, I don't remember, 1 month ago. Just we start again to get ratification, and this is a good sign. Of course, we have a very specific momentum now with the Ukrainian war, but this should not stop us to work on violence against women. Even more, because we know that every violence, every war, it's taking with himself a lot of sexual violence and violence against women, domestic violence, and so on. Thank you.
Thank you very much. Floor to Raffaele Sabato, who is the Italian judge at the European Court of Human Rights. No need to presentation here for the court.
Thank you very much. It's always a great pleasure to come back to Pisa. We as judges of the Strasbourg court are, so to say, very happy and even consider it a pleasure and at the same time a duty to devote some of our free time on a voluntary basis to this kind of outreach programs. It gives us the opportunity to disseminate information and maybe also to learn, which is even more important, new perspectives and establish important relationships for the court. This is especially true for Pisa, of course, because we read your motion with much attention and great interest. My objective today, as I agreed with Professor Martinez, was to sort of give some basic information on concepts of access to justice related to the, so to say, vocabulary that we use in Strasbourg, which is slightly different from the policy approach that you would have under the Istanbul Convention, etc. And then to clarify the basic criteria on which we carry out our supervisory role on domestic implementation of basic human rights in this very delicate area of gender-based violence. So first point, the difference between access to a court and access to justice. This is very clear to everybody. I just recap the convention albeit implicitly, deals with access to a court as a component of the civil limb of Article 6. So it has very little to do, this concept, with our topic today. The Convention does not provide for a generalized right of access to justice in any field, but the Convention is a living instrument. Therefore, our case law, as has been said already, has set up a very clear interpretative framework under which this broader concept of access to justice can also be referred to the issues of gender-based violence and violence in general. Let me, at this point, mention that, of course, we have Article 2 of the European Convention, which not only involves a negative obligation of the state not to take life away from persons that are subject to its authority, but also what we call positive obligations, both substantive and procedural, referring to the so-called substantive positive obligation. This involves a primary duty to secure the right to life by putting in place effective criminal law provisions to deter the commission of offenses. So provisions backed up by law enforcement machinery for the prevention, suppression, and punishment of breaches of such provision. Okay, so this is the substantive part. In certain conditions, so not always, because the state is only directly responsible for the negative obligation of not taking life by way of state agents, the state may also be held responsible for the taking of life or attacks to life by private individuals under what everybody, I think, in this room knows is called the so-called Osman test. And this Osman test has basically two limbs. The authorities know or should have known that an immediate threat to life to a specified individuals by another specified individual might take place. At that point, this additional duty arises, which is the duty to take preventive operational measures to protect the individual whose life is at risk. Now, the idea is that this is a general duty. So the problem in our court has been to discuss whether or not this Osman test should be tailored to the context of domestic violence. And the discussion has ended, and I will tell you how, with this judgment of the Grand Chamber of our Court of 2021, so a very recent one, Kurt versus Austria, which I'm sure was one of the materials that you have had in your ELaN project. In this judgment, the Strasbourg Court has developed on a number of precedents that also, you know, Opus versus Turkey is the main always cited case, but also Talpis versus Italy, which is a very peculiar case in itself. In court, I will concentrate on that when dealing with the a procedural issue of so-called exhaustion of domestic remedies that we have to deal each time. The Grand Chamber made an interesting distinction, which I think is important for your seminar, which is basically that there are remedies domestically, so this is a concept of access to justice, that are aimed at redressing a harm that has already occurred. So basically the possibility to have a criminal trial investigating and finding people liable for the possible taking of life or attack to life. But there are also remedies that are aimed at preventing a future harm. And these remedies, the latter, do not involve an issue of exhausting domestic remedies, in the sense that, of course, a woman who is under attack may ask that preventive operational measures, excuse me if I use this term, but I refer to protection orders, barring orders, taking the woman to a safe shelter home or similar measures. The Osman test is not based on the fact that the woman has to file a report or a complaint herself. The Osman test is in the sense that the authorities know or should have known. So the source of knowledge is irrelevant. Therefore, this latter part does not concern exhaustion of domestic remedies, and you cannot put on the victim or on the future victim the blame for not having informed the authorities. This is very typical. This is very important. So there was this procedural clarification, which is very relevant to sort of putting the idea of access to justice in the context of domestic violence. In Kurt versus Austria, also the Grand Chamber, now we go a little bit toward the more substantive part, observed that the issue of domestic violence, I'm quoting, which can take various forms ranging from physical assault to sexual, economic, emotional, or verbal abuse, transcends the circumstances of an individual case. It is a general problem which affects to a varying degree all member states and which does not always surface into the public sphere, since it often takes place within personal relationships or closed circuits and affects different family members, although women make up an overwhelming majority of the victims, sadly. So basically, the court recognized that the Osman test should be done in some ways, but it is not derogated in any of its passages. The targeting of children, for example, it was the case of Kurt. The lady reported a barring order was made on the man not to go to the family home, etc. But he went immediately after, the morning after, to the school, took the child from the teacher and killed the child in Kurt. So the idea is targeting of children in order to punish and torture the primary victim of the abuse. There were also threats toward the family of origin of the woman in the court case. The recurrence and possibly escalating nature of successive episodes of violence, the need to avoid a narrow incident-based approach, which is something that Senator Valente, in my view, too far-reaching remarks and generalizing remarks, however, clarified. Usually, some judges having only one fragment of the situation in front of them say, this is just a family quarrel within a separation or a divorce. So nothing has to be done. It's within the normal things, but then escalation takes place. The realization that domestic violence is person and not place dependent. Therefore, it is not enough to have, for example, a protection order barring a person to go to the family home because you can meet the person elsewhere at the workplace, or as it happened here at the school for the child. And this is most important, this also came about in some Italian cases, the tendency of victims to retract statements and refuse to pursue prosecutions. There is always a hope that I will change this man, and that because of our love, we can go well together after the incident, which is a very natural phenomenon that each and everybody of us has experienced in his or her own life, but still should be risk assessed within a wider group of indicators. That's what court basically says, based on best sociological and penological research available. So the obligations that are sort of tailored on the state in the context of domestic violence by this Grand Chamber can be enumerated as follows. First, and the court abides by them in checking all future cases. This has happened for an Italian case called Landi. So you will see the same list of checks that come from the case law of court. An immediate response to allegations is required. Response does not mean that you have to believe or you have to act, but some response should take place. The authorities must establish whether there exists a real and immediate risk. This is Osman. So immediate and real, both at the same time. By carrying out an autonomous, so it does not depend necessarily on possible withdrawals by the victim of statements, etc. Proactive, in the sense that they should encourage the victim to testify and or other persons to provide information. You don't stay there waiting. And comprehensive. So all the indicators should be considered together. There are indicators that I'm not mentioning, that they are very sad to mention. But for example, the ethnic nature of the family is certainly a risk. The lack of knowledge of the local language of the family, showing isolation from the context, is another risk. And there are religious and other cultural risks that I will not mention because they are disputed in their nature and possible scientific foundation. If the outcome of this risk assessment is that there is a real and immediate risk, then they have to take preventive operational measures, such as the ones I was mentioning before. These preventive operational measures should be proportionate to the level of the risk assessed. Now, what happened? On all these criteria, the Grand Chamber, I was part of the composition, a very lengthy and complex deliberations, an agreement was found. Then coming on the merits of the case, concerning this case of Austria, the killing the next morning of the child, when the previous afternoon the case has been reported, the barring order had been limited only to some measures. The court divided itself into two halves, 9 versus 8, believed that Austria had not known and should have not known that there was an immediate risk as referred to the child. The other half of the court was of the opposite view. So, this is a tragedy that, human assessments are such. In my view, I was with the majority. This confirms that nonetheless, the Osman test is sadly something that should continue to be applied, because if you put yourself in the place of the authorities, half of the people believe that they had enough elements to sort of foresee an escalation, half of the other people. If you take the court as a sort of a sociological poll of opinions, then the other half believes that there were not enough elements to believe that a possible attack would occur on the child. More recently in Landi, which is a case that I wish not to discuss into detail, there was this assessment by the court on the basis of the same criteria of the passive attitude of prosecutors. So basically the police requested barring orders because they had a complete file, and then there was something that went wrong at the prosecution stage. The court found that the national authorities had known or should have known the real and imminent risk that the applicant was facing. This led to the murder of a one-year-old son once more, and attempted murder to the woman. Let me address another little point before mentioning what I would use as a sort of conclusion of this short recollection of all possible things. Let me only think of the things that I could have mentioned and that I will not mention unless there is a specific interest. First, it would be very interesting to discuss the way the Strasbourg court deals with allegations of discrimination. One thing is Article 2, right to life, Article 3, prohibition of ill treatment, and one thing is discrimination. There are specific rules to assess discrimination. There is at some point, once you have given a prima facie demonstration, you know, there is an inversion of the burden of proof, and the role of statistics, the role of NGOs in providing information. In all of these judgments, you will see that the GREVIO is cited, and a look is also given as to whether the national authorities have commented on the GREVIO reports. This has not occurred in some cases. Another point that we will not deal with is the assessment of the experience of complainants during procedures. Because you know that in domestic violence, there is this issue of secondary victimization. So the way the woman is questioned by the police, by the prosecution, by the court, by the lawyers in court. How this takes place, if it involves an excessive burden, if this is repeated too many times, and so on and so forth. This was in some way addressed in a case concerning Italy, and once more, just as in Landi, in the case of JL versus Italy, all of them based in Tuscany. The experience in JL, which we could possibly discuss in the future, is what is the role of the procedural framework in having the victim testify in an easy context. And then what is the role of the judgment? Here, there was a recognition that the presidents and the courts had simplified life for the victim, although she was questioned by 7 lawyers and twice by prosecution, etc. But in the judgment, there were statements that were as such double victimizing, although maybe the victim was lying on a number of circumstances. There were some objective hints that this took place. Nonetheless, the judgment contained such expression as stigmatizing personal wearing well, choices in choice of clothing by the lady, her choice in successive partners, her, and I cite, ambivalent attitude toward the sex, and again, I'm quoting her non-linear life, which objectively went beyond what you can and need to say in assessing the truth or falsehood of statements of the victims. There is another topic that we could have covered, the link between other forms of violence and domestic violence. Basically, this means that we could deal, for example, the link, which also was emphasized in one case concerning Italy, between trafficking and then the family life of the lady that has come under the protection of the state afterwards. So, you know, vulnerable persons that add a vulnerability to their gender position that exposed them to specific forms of violence. Time will not allow to deal with this topic, so I will only make one final remark. And this final remark basically concerns this reflection that I wish to make. So in most of the cases, in Kurt, in Landi, and in all recent cases concerning certain societies, certain countries, you have the assessment by the court that all the criteria that I mentioned to you were met. So there is an appropriate regulatory framework, there is an efficient machinery to enforce and to punish, there is a sufficient training of persons called to, but still you have failings. So those might be organizational failings, might be personal attitudes of the persons involved to downplay allegations of violence, but this is what happened in unfortunately, we have to refer to cases in which there is no sufficient regulatory framework. Criminal law provisions are not capable of capturing the offense of domestic violence as such. And there is a general attitude in society in discouraging women to testify and to put right possible violations. You are wondering where this would happen, and my reference is to a series of Russian cases in which basically bringing of charges is left to private initiative. This is one of the few, until a few days ago, one of the few legislations in within the European Convention which did not provide for any barring order, protection orders, or any other kinds of restrictions. So there is no provision addressing this issue. So this was rather shocking for me. The main case is Volodina versus Russia, Volodina #1. There is also a #2. This is 2019, so rather recent. And in Volodina, you have a recap of all the criteria also concerning discrimination. So let me make reference to that. This identification of structural defects of Russian law was confirmed by a later case, which is called Tunikova and others versus Russia, which is cited also in cases concerning Italy afterwards, just to make the difference. But I want you to be aware. Basically, in Tunikova, we had a clear picture of what the situation of women can be in certain society. We had 4 applicants applying all of them together, One of them had four fingers chopped off during a quarrel within the home. And what followed to this in Tunikova, that's why I'm mentioning it, is that for the first time, the court gave what I don't know if you are aware of this possibility of giving indications under Article 46. This is usually done by the Committee of Ministers. So we declare a violation, and then the Committee of Ministers tells the state what to do in order to eliminate possible general structural problems. No, here we have it in the judgment, and such indications are of a breadth and nature that have been rarely seen. There is the necessity of providing for an action plan. That's usually the Committee of Ministers that ask for such a plan, to change the public perception of gender-based violence, mandatory training for judges, police officers, prosecutors, medical staff, and social workers. So, you know, this is a really all-comprehensive judgment, which, and this is my conclusion, sadly brings us to the inevitable consequence of what happened last week, September 16th, when the 6-month period after the expulsion of Russia from the Council of Europe expired, at least on paper. Until 16th of September, the Russian Federation was under the obligation to respect the convention. And you know what is happening in reality. But the sad idea is that from September the 16th, not even in theory, leaving practice away, many million Russian women or Russians in general will not be, not even theoretically, under the protection of the convention, which at least makes the situation public. I'm sorry that I, so to say, concluded with such sadness, but the topic is sad as such. And so I think that the fact that the 21st century is going this way is very worrying and should be one of our main concerns. I think that this seminar was in this sort of line, and so I'm very happy to be here.
Thank you very much for your very interesting speech. You gave us a lot of suggestions for further research, and we hope you will be here again with us soon. So I don't know if there are some questions from people here in the room or at home.
I have a question.
Please.
So thank you. It was really interesting. And just because I have a concern also as GREVIO, just Kurt versus Austria and Landi versus Italy speak about children killed. And usually we speak about femicide, but there are also children homicide because of violence against women. And yes, it's true, you are right. These are places where there is enough good regulatory machinery, law enforcement system, judiciary system. But the concern, because before we speak about alienation syndrome and so on, is the fact that culturally there is a strong stigma on women that should continue to stay inside the family even if the man is violent. But what is my real concern, and I don't know if you see this also based on the cases that you have done, that there is really a fracture, the fact that the case of domestic violence doesn't consider children inside the picture. Law enforcement justice system doesn't consider children as victim, as witness and victim of domestic violence, like Istanbul Convention doing, because the Istanbul Convention is considering. So there are still a huge gap that have to be in somehow bridged. And this is quite difficult because it's a cultural issue. And cultural issues move very slow compared to whatever we can push and explain. So do you feel that, yes, it's an issue, and how we can bridge this issue? Thank you.
You are asking a question for which I'm not qualified. What I think of is that starting from the myths of Abraham and more closely Medea, children, not only for women, Medea, but also for men, always represent an intermediate object of violence and or sacrifice and or symbolic way of harming. They are part, I am a man, but I expand the same feeling to myself. They are part of our body. And therefore, they are also part of our personalities. Then they grow with their own personality, and it's even easier to understand why you have an intermediate, weaker object of violence in order to harm another person. The possession issue is also another thing. I take it away from you because you have taken him or her away from me, and other sociological things that you are better qualified than I can. What I would like to underline from a, so to say, jurisprudential point of view, and I request also the help maybe of other colleagues in the area of law, that is that what we see is that in some societies where equality is attained, this, so to say, targeting of children is now very, very visible. There was another Italian case in which I voted for no violation because Italy had observed its obligation to redress the damage, Penati versus Italy, in which also there was a killing of a child. So basically in these countries, we have many domestic violence with killing of children. In those other countries in which equality is not attained and there is no sufficient machinery to protect women as such, or it's only very recent, we see the example of Tunikova, in which you still have incredible violence directly on women. I've read statistics concerning the Russian Federation, and the death statistics of women are really, frightening. So that's my only comment, because it's the only thing that I would base on objectivity.
I don't know if you, maybe Chiara, you come here. Maybe. Okay.
I have just one question about the role of Article 8 of the Convention, because if I'm not wrong, you mentioned Article 2, 3, and 14, but I was wondering which would be the role of Article 8, also considering that in cases concerning discrimination and how the courts have to consider the arguments of the parties has been considered. I think about the recent case in January, I think 2022 from the court. And so I was wondering if you can speak a little bit about the role of Article 8. Thank you.
Thank you for this question. I know that you are specialized in this area. I have it in my notes. It was one of the topics that I could have covered, so I'm prepared. The idea is that, of course, the essential object is that you may have domestic violence contexts in which the taking of life or ill treatment as such is not at the basis of the possible violation. Usually ill treatment is always present. So Article 3 is always present. So I would, so to say, requalify your question saying using Article 8 together with Article 3. And basically the court has constantly held that you can use this provision when there is a positive obligation concerning an inherent need that the authorities provide a protection for respect of family life. Adoption of measures in the sphere of relations of individuals between themselves. It's rather difficult to explain in a few words, but for example, in a context of domestic violence, does the country concerned have a regulatory framework providing for punishment for any non-consensual sexual act? Because of course, you can start from this and move also to an Article 3 violation. But if that country has a culture in which you don't need the requirement of consent for a sexual act, it is not rape or any other minor violation compared to rape. There is some latitude in the Istanbul Convention, which, as you know, provides for such a need of criminalization. Well, then you could have a domestic violence context in which Article 8 is relevant. I'm sorry that I made a sort of a little bit shocking reference, but also, you know, repeated sexual situations are common in domestic violence cases. In court, there was sorry that I use this expression, that a non-consensual, let's say so, act that took place in a few days before the final violence, which was in the picture of those that believed that there was an escalation, which was inserted in the context of violence, especially because the two partners had interrupted any kind of personal relationship, although living in the house for some time. So this comes very close to, this is one point. Concerning minors, for example, the idea is that you can have episodes concerning the management and the education or the non-education or abuse by way of neglect of minors. That could more or less be equivalent to the situation concerning sexual intercourse that I referred to before. So you have a number of, there are some cases that also refer to cyber violence within the family. So you have situations in which, you know, the husband plants a GPS within the purse of the lady and then controls all the movements, etc. This can or cannot be an indicator of a gender-based violence, but within a wider context, it would be if the state would condone such kind of acts or would have no legislation providing for punishment of such acts, for example, within the family, you would have a joint violation of Article 3 and Article 8. So my answer is yes, you got it right.
Just a short comment on the positive vision of our future. The Commission has proposed a directive. Of course, this is on the side of the legislator, a directive on combating violence against women and domestic violence. And the proposal is to criminalize rape as a sexual penetrative act without consent. So there's the idea is that to have an harmonized legislation in all member states in the direction that you were mentioning, and cybercrime of the directive.
Since, if I may, GREVIO had its first recommendation on digital violence. So let me refer to that. It's a very interesting thing.
Thank you again. Some other questions? Please, can you come here, please? Thank you. It's oh, okay. Grazie.
Sorry, my question is the following. Since debating over domestic abuse means implicitly debating also about gender roles and relationship, has ever occurred some intromission of political debate and competition in the conversation about this kind of penalties? And would you describe that as an opportunity or a risk, since the theme is a battleground for between conservatism and progressism? Thank you.
Question was for both of maybe. Yes.
Okay, Istanbul Convention is very clear, is referred to women, and as you know, it's there is a huge discussion between conservative and progressive, we can say, dialogue. In fact, Istanbul Convention doesn't mean how Istanbul Convention is based in its principle on the European framework, European Council of Europe framework on discrimination and related also to gender identity, sexual orientation. For this reason, Istanbul Convention were very much attacked, but the focus was Istanbul Convention, was not the other convention. So the use that is done of Istanbul Convention, the narrative that is done on Istanbul Convention often is just to slow down the progress that can be done also through Istanbul Convention related to the what you were saying. So we have to take every kind of opportunity to enlarge the spectrum of human rights and to protect any kind of people that can live a situation of violence, of gender-based violence. This is the real point. And Istanbul Convention says that every person that is living a gender-based violence should be prevented to live it and to protect from this violence. So I don't know if I answered to you, but of course we are working and the debate is fully open. We don't know how it goes, but it's fully open.
I think that there are no more questions. We can thank again our guest today, and I don't know if you want to say something. Okay, so there is a coffee, not break, end of a round table coffee outside, a brunch for those who are here.